For over a century, Adams & Adams has been at the forefront of intellectual property, or as we know it, IP law, on the African continent. As a leading African intellectual property law firm, we understand that intellectual property is one of the most dynamic and debated fields of law on an international as well as on a national level, consistently forcing countries to adapt to developments in commerce, trade and industry, and in scientific and artistic creativity. Even though the intellectual property value will vary from business to business, intangible IP assets like your patents, designs, trademarks, copyrights, and know-how can oftentimes be more valuable to your business than your tangible assets. Today, we will explore the value of intellectual property and the importance of adequately protecting it. I'd like to welcome my colleagues from the Trademarks and Patents Department, Lita, James, and Nishan. Thank you for joining us this morning. If I could get started by firstly asking Lita, in practice we find that IP is often misunderstood and undervalued. Why is IP important and what does this entail?
Thanks, Lucas. That's a very, very good question. There are a number of reasons why intellectual property is important, but I think I'll just touch on 2 or 3 for the sake of brevity. So the first reason is that intellectual property is actually an asset in the business. It sounds obvious now that I say it, but that's not always the case. However, it is an intangible asset that adds, value to the business, enhances the value of the business. It's not always possible to list it as an item on the balance sheet. However, if you do sell or transfer intellectual property, or even if you license it to third parties to create revenue streams, you could potentially list that as an item on the balance sheet. The second reason is that intellectual property sets a business apart from its competitors in the marketplace. It makes it very marketable and also enables it to position itself attractively to funders and investors. The third reason is that intellectual property, once registered, can potentially be pledged as a security for a loan. That's particularly the case for registered trademarks and patents.
Thank you for that, Lita. If I can move on to James now. James, from your years of experience in the field, what are some of the common misconceptions that people tend to have when it comes to IP law and specifically to patents?
Thanks, Bilkis. I jotted down a couple of legal points, but then it occurred to me afterwards that even before we get there, there's a more personal point that I've seen there are many misconceptions about, and that is that we as attorneys are very difficult to contact, or you should only do it if you also are in a corporate or a professional person or something like that, but that's really not the case. And in fact, very often your intellectual property would be so much easier, your intellectual property journey would be so much easier if you just contact us and have a quick discussion before you make a mistake or get started or make a possibly expensive decision. And we're quite friendly people. You can contact us on our website or by email or just pick up the phone. And in fact, with this pandemic, video consultations have become very, very useful. So with that said, there are a couple of legal misconceptions that I've picked up on, especially with respect to patents, because that's where I work. And the biggest misconception I've come across, and this is very difficult for some first-time inventors, is that you can make your own invention unpatentable. And that's because in order to be patentable, an invention must be new or novel, which means it mustn't be available to the public or disclosed publicly. And I get the question so often, inventors say to me they've created this new product, it's starting to do really well on the market and their sales are picking up, and now they've been told maybe they should look at patenting it. And unfortunately, because they've put their own product on the market already, they've destroyed the novelty of their invention, so it becomes too late to patent it. So if you've got an idea or a product or a concept which you're thinking about patenting, please, before you disclose it publicly, before you start selling it commercially, make contact with us and then we can advise you, is a patent the right option for you? And we can secure your rights before you make any costly mistakes. The second thing I've come across fairly often is people think that intellectual property protection is just too expensive for them, so they don't bother. And sometimes that's actually true, depending on the type of intellectual property you're going for. Other times it's not true at all. Some types of intellectual property can be relatively cheap, some are even free. Copyright, for example, vests freely and automatically. Patent protection, it's true, can become expensive if you start filing multiple patents around the world, especially if you've got to pay official fees in dollars and euros and things like that. But to start the process is relatively inexpensive, and I've also had people say to me after the fact, sure, I thought I was saving money by not filing a patent, but now I've got no protection and anyone can copy me, so it's turned out to be a lot more expensive not filing a patent than filing one. Another thing inventors sometimes think is that now that they've made an invention, that's the hard part of the work done, and they can just sit back and watch the money roll in. And it would be nice if that's the case, but it's not most of the time, unfortunately. A saying springs to mind. Someone once said that if you invent a better mousetrap, the world will beat a path to your door. But that's proved really not to be true. So very often, coming up with a new idea is only step one in the process, and we can certainly help with patents and protecting it and making sure that your rights are secure and all of that. But step two, this is where some inventors do fall down. Step two is marketing the invention, and that doesn't really happen automatically. You've got to do it, you've got to be a bit proactive. So yeah, unfortunately, a bit of a misconception is I've come up with a great idea, now I can sit back and big tech is going to offer me $1 billion for this idea and I don't need to do anything. And unfortunately, it very seldom happens that way. You've got to start marketing, you've got to create a revenue stream, and once you do that, then you can start making money, hopefully seeing some royalties come in, and a patent becomes very helpful. But inventing is often only step one of the process. Marketing and putting the product out there, it's a very important step, and that's step two, which a lot of people don't realize until they are thrown into the middle of things that they have to do. So yeah, those are a couple of the common questions and misconceptions I've come across. And like I say, in most cases, just chat to a patent attorney like me, a trademark attorney maybe, before you make a decision, because we can really help. And if you start off on the correct path to begin with, it'll make your life a lot easier in the long run.
Thanks for that, James. I'd like to focus on a specific point that you raised. You mentioned that a failure to protect your trademark could actually, or your patent in your case, could actually lead to a more expensive scenario for the client. So protection right at the outset is extremely important. As we know, protecting IP can have global implications. With a unique background here in Africa, Adams & Adams offers clients access to professionals with extensive knowledge of intellectual property law across the continent. Nishan, what unique advantage does this offer to our clients who are seeking to protect, enforce, and commercialize their intellectual property?
Thanks, Lucas. So in general, IP rights are territorial in nature, which means that you need to protect IP rights in a particular country. Okay. However, the online marketplace has opened the doors for businesses to commercialize their IP on a global scale, right? So going back to your question, yes, it is important, and IP will have global implications. It's therefore critical that clients ensure that they have adequate protection in various territories, including Africa. Now, there are difficulties in certain regions in Africa, but the good news is you can protect your IP rights in 52 out of the 54 countries in Africa. As you mentioned, Wilkes, we have extensive knowledge in the IP laws in Africa, but more importantly, we have the practical experience in the continent. Okay, and I think that's an important distinction that we all know. There may be a difference between theory and practice. For example, in theory, there are two regional systems that protect IP in Africa. But in practice, one of those systems are not that effective for trademark rights. Also, in theory, you may designate several African countries when you file an international trademark application. But in practice, there are only a handful of countries in Africa that actually process these applications. We have knowledge of what happens at the registries. So we'll be able to advise clients on where and how to protect their rights. Insofar as enforcement is concerned, we are at the forefront of development of legal or IP jurisprudence throughout the continent. Most African courts don't often deal with IP cases, so it's critical for clients to ensure that they receive advice from a professional that not only is familiar with the law, but has practical experience in litigation in Africa. And that's a key thing. So to answer your question, Lucas, the unique advantage that we offer clients relates to our extensive, widespread, practical experience in Africa. We know the law in Africa, but more importantly, we know how to practice the law.
Thank you, Nishan. That's excellent. That is exactly the advice we needed to hear. And I'd like to thank my panel for their insight and expertise and raising such important issues. Thank you all.
Thanks, Lucas.
To minimize the risk of losing an original idea or trademark to someone else, it is imperative that you protect the intellectual property rights in your original works and in your trademarks without delay. With the help of Adams & Adams, an internationally recognized and leading African intellectual property law firm, you can ensure comprehensive protection, enforcement, and commercialization of your intellectual property.